Prashanti, could you tell us what are the key aspects of the H-1B modernization rule proposed by the Department of Homeland Security, and most importantly, how might they influence the issuance of RFEs?
So, yeah, with reference to the modernization rule, we spoke about it a little bit in the last show as well, but to give more details in this show, there are three important or key aspects to the modernization rule that I wanted to touch upon. The first one is they talk about bringing back the contracts and work orders. In a consulting company scenario where the H1s are being filed by IT consulting companies where the beneficiaries are working for third parties. The Previously, they would ask for contracts and work orders between all the possible parties, between the vendor, the end client, the sub vendor, and they would ask for these contracts to be valid for the validity of the H1. So if we're asking 3 years on a H1, they would ask for a validity of the BO for 3 years. Otherwise, they would give the H1 for a lesser time. So then in 2020, there was a lawsuit filed by IT Serve versus Cessna. And in this lawsuit, it was decided that it's unlawful to ask for the itineraries and detailed contracts. So USCIS agreed then not to ask for detailed itineraries and not to ask for contracts for the entire duration of the H1. As a result of which now H1s are being approved. They can still ask for work orders and contracts to a certain extent. They want to know if there is availability of specialty occupation work or not. And based on that, they can ask for it, but they haven't been doing that as much. But now with the modernization rule, they're trying to bring back that as a regulation so that the court order will then be null and void because there's an actual regulation to that effect requiring proof of specialty occupation work. And so they're trying to bring back those the requirement to provide contracts and work orders for the entire duration of the time. They have, however, have said that detailed itineraries would not be required, as the that information is on the LCA anyway. So you don't have to show that you have work for the entire period of time, but you have to show that you have some specialty occupation work. And then they might ask for contracts and work orders and MSAs and POs between all the parties involved if there's more than two parties involved. So that's one thing that is not good news. The second thing is with reference to how they define specialty occupation. So they've said that it's not necessary that the bachelor's should be in a specific field. They said it could be in several different fields and it's still a specialty occupation as long as those different fields are related. Just to give you a background, USCIS has denied cases in the past where the job requires, for example, a bachelor's in computer science, engineering, math, physics. They say it's not a specific specialty, so it's not a specialty occupation. Now they're saying that as long as those majors are related, say computer science, electronics, information technology, as long as they're related to each other, the job can require more than one major and it'll still be a specialty occupation. So that's something else that they've said. So the specialty occupation, the POs and work order requirement, and no requirement for detailed itineraries. So these are some of the things that they've come up with in the modernization rule.
Okay, okay. And will the master's degree from US will be given more importance in comparison to the bachelor's degree?
No, it's still the same. As long as you have a bachelor's, the minimum requirement for a H1 is a bachelor's in the field that they're going to be performing the job in. There's no requirement that there should be a master's. The only thing is that when you're doing the registration for the H1B registration for the the quota, if you look at the H-1B cap cases, there is a separate category for US master's degrees,
Mm-hmm.
uh, and that's a 20,000 additional cap. Additional numbers are available for master's degree holders, which are
Uh-huh.
not available for bachelor's degree holders. So what happens is if you qualify under the master's cap, excuse me, you'll be selected under master's cap. I mean, your lottery will be run under the master's cap, and if you're not selected, then it'll be run again under the bachelor's cap. So you'll get two chances at the lottery if you have a master's degree. So that's definitely an advantage. But from the point of a specialty occupation perspective, the minimum requirement is a bachelor's, not a master's. So that really doesn't make a difference. So also, I think your question also had a second part where
Right.
you were
Yeah.
asking about the RFEs, how it impacts RFEs. So it's hard to say right now because remember the modernization rule is only a proposed rule. It's not something that has been finalized. They're still working, waiting for comments on the rule, and then they'll decide finally. They'll publish the final rule, so we don't know as yet. But if it stands as is, then it might impact some occupations. They might, even though it seems that they're opening up H1s to more occupations, it might actually end up restricting the occupations that qualify for a H1 because it depends on really how the officer then will use that kind of the rule that is proposed. So they can easily say that the H1B is not a specialty occupation because they can easily say that the majors are not related. So let's see how
Okay.
it goes.
All right. Okay. Also, I have one more question. With this particular question. So, given the change, given the changes, such as the shift to a beneficiary centric registration system, what type of RFEs might become more common?
So beneficiary centric, again, that's one of the proposed rules, which I mentioned three. This is the fourth one. They plan to change the registration process, so that the lottery is picked not based on the registrations that are filed, but based on the passport number of the beneficiary. So if a beneficiary files for 10 registrations, that'll be counted only as one because they'll identify the five registrations as one through the unique passport ID, and they will only run then that application one time through the lottery. So they'll count it only once towards the lottery. So it'll definitely affect. It won't really affect RFEs because when registration is doesn't have any RFEs, it's the H1s that actually have RFEs. So at the point of when registrations are done, the way it'll affect beneficiaries is that it's no longer useful for them to file multiple registrations because whether they file 10 or they file one, they'll only get one pick, one chance at the lottery, one draw at the lottery. So it makes no sense anymore for the beneficiaries to file, multiple registrations through different employers. I mean, if they have separate job offers through each employer, then they
Mm-hmm.
can still do multiple registrations and only get one pick. And once they are picked, then they can decide which company they can file their H1 to if they've filed more than one registration through different companies. So that's what's going to happen. No RFEs as such because registrations don't have RFEs. So and it doesn't affect once they get selected. I don't think it'll affect the H1 RFEs if anyway they have changed the law. If they don't change the rules, then of course, if beneficiaries do multiple registrations, and if there is collusion between companies, so two companies decide to file for the same person,
Mm-hmm.
then there could be RFEs saying that there's collusion, and they could, um, then deny the case by showing that the same set of beneficiaries applied through two or more companies.